Good morning. I see some people jumped on right on time, as we do every month. We're going to give people 2 minutes to join the Zoom, and then we will talk about today's subject. In the interim, as always, enjoy the song Zoom by the Commodores, of course, featuring Lionel Richie as the lead vocalist. The Commodores are from one of my old hometowns, Tuskegee, Alabama. And Zoom was a song from 1977. Wish I had taken it as a direction to buy Zoom stock right before the pandemic. Oh, one more minute. The star at night. I'd like to know the taste of heartache in my life. Yep, I still see people jumping on. Yeah, give kids just a few more seconds. Well, hello. I am John Miller, founding attorney at Rock Solid Law and Title in beautiful Ponte Vedra, Florida. You can probably see through my screens that there's clouds in the skies today. For anybody watching on the video replay on our website, today is the day when we are waiting to see what's going to happen with Hurricane Helene. She or it is currently heading toward Apalachicola on the west coast of Florida, and we here in the greater Jacksonville and Beaches area have some wind this morning, but it's actually a beautiful morning. But we're expecting some pretty significant wind and rain this afternoon, evening, and overnight. So I hope everybody will be safe, and I really appreciate you taking the time to join me this morning to talk about new Floridians and estate planning and what needs to be done. So if any of you are new to us or to this series, we started it when the pandemic hit. We were doing weekly for a long time. We've gone to a monthly cadence now, which seems to work for people. And we cover subject matter in the areas in which we practice: estate planning, inclusive of probate, real estate, closing, title, and escrow, and general business. I believe that small business is the heartbeat of the American economy, and we love representing entrepreneurial small business people. I believe that home ownership is the cornerstone of the American dream, and we love practicing real estate, seeing new homeowners, and of course, a strong nuclear and extended generational family is the bond that I believe is most essential for our American culture. And we look at estate planning multi-generationally in an effort to strengthen those bonds among families. So if you have recently moved or moved anytime to Florida, welcome. I think the current stats are a little more than 2,000 people per day relocate to Florida. I first moved here in 1965. Haven't been here continuously since, but have spent significantly the greatest proportion of my life in the first St. Petersburg and now Jacksonville area. we welcome you. We hope you enjoy our beautiful natural resources. We hope you enjoy our lifestyle. And we appreciate that you appreciate that you are now a Florida resident, and therefore your life is lived under the laws of the state of Florida. So the subject of this particular webinar is, what does that mean with respect to estate planning, New Floridian? Well, for those of you that have not done a revocable living trust or any trust or a last will and testament, that means that when you do that, they will be subject to the laws of the state of Florida. For those of you that have done some estate planning already somewhere else, or know people that are coming to this state um, to live, well, they need to do that, have their plan updated in Florida and subject to our laws. So I'm going to talk about that for the next few minutes. For those of you that are new, there is a chat bar down around here somewhere at the bottom of the page. I will do questions and answers. Go ahead and throw them in there. I will leave time at the end to answer them, but if something is just urgent, I'll jump from whatever I'm talking about and talk to you about that at that point, because I want this to be what you enjoy. So the for instance I like to start out with is, many people who move to our state come from a state where in the probate process, the person that they have recommended to represent their interests as their fiduciary before the courts is called an executor or executrix. That is not the terminology we use in Florida. The very same role is performed by a person who is called a personal representative. And I like to joke that we here in Florida like to wear our flip-flops, and we just call that a PR. So when you hear somebody talking about a PR before the court in a probate action, well, that's the same thing as an executor or an executrix, as nearby as Georgia and as far away as the Northeast. For instance, New York and New Jersey both use that terminology. So we have a lot of people talking about that. I will also occasionally see lawyers using that, and that's how I know that they're probably pretty new to the practice in our state. Now, I brought up that as just a good example that there are things that are different, and there are probably things that you don't know. So my recommendation is that you come see us or go see another lawyer who has expertise in this area and practices regularly in estate planning, who can help you, if appropriate, with either a last will and testament based plan or a trust based plan. So really quickly, what's the difference between those two? Every last will and testament that's not associated with an active trust is going to court. It's going through a probate proceeding. I don't favor those. It's expensive and time consuming for the family. And it also is somewhat public. So the laundry of the family is there for others to see, as well as it's where I've observed over my almost 40 years of practice that families go to fight. So if you want to avoid that and you do have the assets to make it appropriate, a family or living trust is the way to go. We can determine that by just talking together. We can call it a consultation if you like, or a conference. And we will, as a result of your taking the time to attend this webinar, waive the consultation fees. So the initial chat we'll have to determine what's appropriate for you will be without a charge. So we would love to see you come in and talk about that. Now, we talked a little bit about a personal representative, and I would much rather see the fiduciary helping you be the trustee you've selected, who is not under the control of the legal system, the judicial system, and a judge in distributing things the way that you have set forth that they are to be distributed. Now, welcoming you to Florida, one of the things I get to tell you about is our homestead law. In my opinion, Florida has about the best homestead law in the world. You are protected in your home from all creditors, except the mortgage company, the federal government, like the IRS, and someone that you have hired to do repairs on your home. I say swing a hammer. Those folks have what's called a contractor's or mechanic's lien against the home to collect their payment for the services they provide. So there are other layers of homestead. Our homestead laws were established when we were still a territory back in the 19th century. And they protect, for instance, a surviving spouse to have a place to live during their lifetime. Essentially, the initial incentive to get settlers to come to Florida. Remember, it was before air conditioning, before electricity. We had mosquitoes, we had alligators, we had swamps. And to get typically the wife to uproot her family and move it here so the husband could take a chance to build something economically for their family. The territory said, all right, well, if everything fails, you at least get to keep your home and you will live there for your life. No creditor can take that from you. So we have a very, very strong homestead law, which has, after we became a state, been adopted into our state constitution. So it's a constitutional right to live in your home free of creditors for your life. The other rights are that one spouse cannot transfer the property without the other spouse joining in the homestead. And that is even if the other spouse is not specifically mentioned on the title of the deed, but that they are living there as their home. The homestead many people are familiar with is the decrease in the taxable value of the house annually as a result of it being your homestead. So we have multiple levels of homestead in Florida that provide the first level of asset protection. And we as estate planning attorneys follow the first rule, which is don't do anything to mess up your homestead. So thing number one that you would want to look at when you come here is, how is your homestead held? Is it individually? Is it jointly as a couple? Is it in a trust? What sort of deed is it subject to? And then you would want, if you have a plan that was created in another state, you'd want to have a lawyer here review that plan and make sure that it was executed in accordance with the signing requirements of the state of Florida. So I have, in the distant past, represented some folks in a probate matter where the will was executed, I believe it was in New York, but it was in a northeastern state that had different and lesser signing requirements than Florida to have a document properly executed and to be able to be submitted in evidence to the court for a probate procedure. In that case, which we didn't get until after it was a mother, the aging mother had passed on, we were required to go find the original witnesses to the will and get affidavits. The will was very old, and it required finding a retired lawyer in New York and getting him to execute an affidavit that he had indeed drafted and that the lady had signed that will. It was an expensive process. It cost thousands of dollars. Had we been able to meet with her during her lifetime, we could have simply resolved that with an affidavit. But many of the documents, and by the way, as an aside, that was a probate matter. And I want to mention to you that I am firmly anti-probate for the reasons I mentioned before, mostly because I've seen families that will never talk again after the litigation that ensues in probate. I am not in favor of probate. I will do everything I can to help your family stay out of probate and to have the assets passed from one generation to the next or to whoever you wish without the amount of it being diminished by the cost and expense in terms of money and time, not to mention emotion, which may be the most important factor in the probate process. So all probate means litigation, folks. That means a lawsuit. That means the courthouse. So then I want to mention that the ancillary documents that go in an estate plan, such as a power of attorney, a healthcare surrogate, and what has been called a living will and is sometimes now referred to as a written declaration to physician regarding life prolonging procedures, a better descriptive but very lengthy title. All of those things are created subject to state law. That doesn't mean that they lose entire effectiveness once someone moves to our Sunshine State. I'm saying sunshine with a wink today, given the cloud cover from Hurricane Helene. But I highly recommend that those documents be re-executed with reference to Florida law. Since you've now become a resident of the state of Florida, the documents need to be done appropriately in accordance with our law. And if you take a look at your documents, in all likelihood, they recite the statutes of the state in which you executed them. So another little update. We're in 2024 as I'm speaking. So 13 years ago, we had a significant change in the laws of the state of Florida with regard to powers of attorney. And just quickly taken away, we're springing powers and general powers. And so we have to be very specific to make our powers of attorney effective. So we'd want to make sure that your power of attorney is effective for the purpose that that you wish it to be so. So even if you are in Florida or know someone in Florida that has a very old plan, those need to be updated. And of course, anyone coming in from out of state who does a new plan with us, they will be updated as appropriate. Okay, so those are sometimes you hear them called durable family, but powers of attorney for financial purposes, healthcare surrogate for medical purposes, and then the written declaration to physician regarding how you want to be treated in your final illness. With respect to that written declaration, or what is often referred to as a living will, Florida's a little bit different. We do not require that your healthcare surrogate make the decision on when to terminate life-sustaining care when you're in a terminal or vegetative state. You have done that in the document yourself, and you have directed the primary care physician together with a consenting physician to make that determination in accordance with your wishes. It's kind of nice because you don't have to, as I would say, lay that responsibility on someone in your family to make the determination of when that time has come. Physicians are still subject to the Hippocratic Oath. They're going to tend toward saving life, and that's why these declarations are so important, so that a lifeless brain and body is not kept alive, adverse to the individual's wishes, just by means of artificial machines and other things. So just a couple of inside tips with regard to being a new Floridian. Will requirements I referred to briefly before, and it's think you can scrawl your will on a bar napkin and have it be legal? Think again. I have a lot of people that want to just write their wishes out. Florida doesn't recognize most holographic, which is the fancy word for handwritten wills. So you're going to need to make sure that your will, your trust, and your affidavits and other documents are properly signed, or the term is executed under Florida law. So you need legal help to get that done. And then we were referring to living will or written declaration of physician moments ago. If you want one, you'll need to have it properly witnessed. For instance, that at least one of those witnesses needs to be a non-spouse or non-blood relative. Needs to be a non-spouse or non-blood relative. So as you can see, there are specific requirements under the state of Florida that you will want to make sure are followed so that your wishes are carried out. I mean, that's the whole reason you do your estate planning, is so that you have some control and that the people that you want to have take whatever you don't use up do. Just another tip, you're in the Sunshine State now here in Florida, with regard to your cell phone in your automobile. Distracted driving laws may prevent most cell phone use in Florida, but arguably you can still text at a stoplight. So put down the phone, drive your car. We got 2,000 new people in our state every day. I come to work on A1A, and it's more crowded than it's ever been. Like I said, I came here nearly 40 years ago to stay, having had my childhood here as well. So don't text and drive. That's dangerous. It seems like a good day also, given that we've got a weather event occurring. We're under a watch or warning right now in Duval and St. Johns County. The sand dunes and sea oats are there for a reason. They're there to hold back the sea when we have these kinds of events. So please stay off of them. Our laws require that you stay off of them, and don't pick sea oats. They're there for a reason. They're there to keep the dunes there, and the dunes there to keep the water back out of our homes and cut down on damage. Now, recap. If you're new to Florida and you've never done your estate planning, you need to come see us or somebody just like us. If you're new to Florida and you have a plan that was created in another state, you need to come see us or someone like us to have that, as one of my clients called, Floridaized. I have not trademarked that yet, but I'm thinking about it. So then finally, the advice, my advice, the advice of our firm, is that when you have at least several $100,000 of assets and a homestead, if you own a home, you need to talk about keeping it out of probate and those other assets out of probate. And the way you do that is with a trust-based plan. We would be happy to talk to you. I'm sure there are other attorneys out there that would as well. But we appreciate you spending your time with us this morning. And for doing so, we'll absolutely take your call, take your consultation without any fee. Just mention when you call to whoever answers the phone, it's probably our wonderful Alex, that you were on the new Floridian webinar. So I'm not seeing any questions at the bottom. Those are essentially the things that I wish to relate to you today. I really, really appreciate you joining us. I welcome you to Florida. I have found it's the most wonderful place to live. And I have practiced here 40 years, nearly 40 years now. Next year will be 40. And lived here, I guess, 46 years. It's a great place to make a life. If you have any questions that you didn't want to ask in front of the group, please feel free to email us at questions, that's with an S on the end of the word question, at rocksolidlaw.com, and we'll get you an answer. I'm going to let Lionel Richie and the Commodores play again, and I want to wish you a very safe weathering of the current storm, and I hope that we'll get to see you in the future. Have a wonderful day, everyone. I'm John Miller, founding attorney, Rock Solid Law and Title. Bye-bye.